Our next case is People versus Lyman. This is a 20-minute grant. Both sides have 2 minutes of a free fire zone, and you may reserve time for a rebuttal. I believe Mr. Rustuccia is here and has 5 minutes. Are you going to manage that time yourself, or is it separate?
I will keep track of the time. I intend to watch the clock, and,
Okay.
and once I get close to.
We have 15 minutes on the clock. Oh, we just moved it to 20. So, and then if you want to reserve time for rebuttal, just factor that in as well.
Absolutely. Thank you. And may it please the court, John Voitala, representing the appellant in this matter, the people of the state of Michigan. As stated in our discussion, I will be giving 5 minutes of my 20 minutes to the amicus, the Michigan State Police in this particular case. I'll try to keep track of the time. And the unlikely chance that I have any time left, I will reserve that for a rebuttal. The Court of Appeals found that the current SORA facially is punishment, not specifically that as applied to Mr. Lyman or even situated individuals, but to every offender that is placed and required to be on the registry, that it's punishment for each one of those. And in constructing the 2021 SORA, the legislature had a specific goal not to make it punitive. They did this by addressing some of the things that the Doe's courts, the federal courts spoke of, and constructing that. Those are things that were also repeated by this court in Betts, and eliminated those things and amended those things to make it more less punitive or non-punitive, but also substantially implemented SORNA, the federal national baseline of registration requirements. Those are requirements that the federal government has indicated that the states should include in their registry. And what SORA, the current SORA, is nearly identical to SORNA. And the federal courts that have looked at SORNA have uniformly stated that in the aggregate, those provisions are non-punishment, they're non-punitive. So those decisions are essentially persuasive and extremely persuasive to the point that the Court of Appeals in this particular case was incorrect. And SORA, as SORNA is, does not constitute punishment. With that, open to questions.
How do you respond to the other side's argument that if the only thing about 2011 SORA that made it punishment were the geographic limitations, the school zones, and some of the mandatory in-person requirements, in Betts we held that we couldn't sever those and save 2011 SORA. So if that were the case, if 2021 basically only did that, why is that not still punishment? Wouldn't we have severed it, I guess, if that was enough to cure the problem with 2011 SORA?
Well, I mean, the court in Betts, you indicated specifically that taking all of that in just piecemeal was just going to make the statute inapplicable. I mean, you couldn't operate with the statute that existed. So what the legislature did is they did make those changes. They did eliminate many of the things that Betts spoke of. And obviously the amendments occurred before Betts occurred, or Betts was decided. But they did much more. I mean, they sort of set out the fact of both they got rid of the school zones, which was a huge thing, and which, as court specifically said, was a major part, and also the Doe's court stated was a major part that made this punitive and not regulatory. But they also set out the requirements that you don't need to report the minor changes in person. You could do it by mail now, and other things. So it wasn't just the fact that these three particular things were removed. More was done in the legislature, but by doing so, they made the statute operable, which wouldn't be able to occur supposedly by this court's analysis by just severing those particular
What about
elements.
the argument that the change actually perhaps made it worse with, as far as the public reporting and removing the tier classifications? So now everybody looks the same, which is actually worse than had the public been informed of their tier.
Well, I mean, it's kind of interesting that the tier things are things that this court and also the Doe's court specifically said are things that you should remove to make it non-punitive, are now the things that are being claimed to be what makes it now more punitive. Now you've removed those things.
Well, it's not necessarily just removing it's the publication of it, right? It's the putting it on the internet that says now everybody could be considered the best or the worst offender, right? I mean,
And I don't think the registry does that either. What the registry does require in the public registry is it does put out the crime that was actually committed. It's not just that this person is a tier 1 or tier 2 or tier 3. It indicates, as it has before Betts and in 2011, in 2006, I believe also, that it states the actual offense that this person committed. It doesn't just rely on the fact that this person is whatever the tier is. It states the actual crime that person committed, and the public can make their determination based upon that as to what level of danger they feel this particular individual is.
okay, one final question, sorry. You say that the 2021 SORA is very nearly the same as SORNA, and federal courts say SORNA is not punishment. What would you highlight as the sort of space between 2021 SORA and SORNA, and why is that difference not sufficient to make it punishment here in Michigan?
So there is some area. One area is that is applied specifically to this particular case is that SORNA in itself, Mr. Lyman would not fall under SORNA because this was a parental false imprisonment.
A
So that's one
non-sexual offense,
for non-sexual
non-sexual
offense.
conduct.
Right. So under the SORNA, it does not. It excludes parental kidnapping, parental false imprisonment from it. So that is one difference. Do I think that is a significant enough change or a significant difference between SORNA and SORA to then say now SORA is punishment where SORNA is not? I don't think that is in the aggregate, because that's what we need to look at is how everything in the act, you look at the whole thing and see if facially that is going to be punishment.
That's kind of a big thing, though, isn't it? I mean, that's sort of the big part of this case. This is punishment, putting on a sexual offender registry for conduct that doesn't contain sexual conduct. And that's, I mean, just sort of layman or logic, isn't that a problem?
Well, my argument is it's not punishment. And second of all, if the court of appeals, and I know this is the argument that the MSP has, is that if you are to find this to be punishment, then it should be punishment only as to Mr. Lyman or to similarly situated individuals. That's not what the court of appeals did. What the court of appeals did said, facially, for anybody, whether you committed a non-sexual offense like Mr. Lyman did, or you committed just a heinous series of CSC 1s, it's punishment for everyone.
Okay.
Counsel, I wanted to just turn to sort of the Mendoza-Martinez factors and just whether, being on the registry is similar to our traditions and history of punishment. And obviously, there's an argument put forth by defendant that the registry looks a lot like probation. And I certainly can see some merit to that. In some ways, it's longer. A lot of probation periods, have a very finite time that they end. Depending on the nature of the offense here, you could be on this forever, 10 years to life. So I'm just wondering, how do we say this isn't similar to probation?
Well, and some of the similarities between our current SORA and the Alaska ASORN, or I think it's what it was called, in the Smith v. Doe. I think there is some similarity in that particular regard. In the U.S. Supreme Court case in Smith v. Doe, sort of found this, yeah, it had its similarities to being probation or parole, but ended up finding that this was non-punitive for that.
Right.
I think there are differences also in the fact that you don't have, as with parole and probation, you have someone that is specifically assigned to you to supervise you. You have someone watching you constantly. That does not exist with the registry.
Right, except for the general public that has access to the registry at all times.
Well, and that goes to the rational basis for the statute in itself, is for the protection of the public against potential dangers that exist out there. And so we want the public to view it. That was the intent of the registries, is to have the public view it and make their own decisions. You don't have an individual that is following this person around and making these determinations as to whether they're in violation or whether they're reporting or they're doing this. It's the public that's making the determination, and that's what we want them to do, to keep an eye on their neighbors, basically.
So does it matter that things have dramatically changed since Smith, which I think was 2003 maybe?
Mm-hmm.
Does it matter like how the internet works and social media and the fact that you can get alerts set to your phone, you can have a map showing exactly where everybody lives? Does it matter that it's changed a lot what that public interface looks like?
I think the changes in the internet, the more widely use of social, whether it's TikTok or
It changes
I'm a little
very
too
quickly.
old to know some of these things, and I don't participate in them. But I think because you do a simple Google search, and you're going to find most of, if not all of the information that is on the SORA registration. And the difference being is that if you just do the Google search, you don't know whether that is actually accurate and truthful information, whereas with the SORA registration, you do know this is truthful. So this is truthful information based upon conviction, what this person was convicted of, their location, things that are on the Secretary of State websites. All this information is in the public arena already, basically, most of it at least. So I think that change in it actually makes it less shaming and less of punitive in that regard, because whereas before, most of the information you could get was just going onto the SORA registry and seeing this information, whereas now, because of the widespread use of social media and the internet, that information is available even absent SORA.
Going to reserve time?
I will give Mr. Rosusha his time and reserve the rest for my rebuttal. Thank you.
Good morning. Eric Rastusha, appearing on behalf of Michigan State Police as amicus. And I'd like to make 2 points this morning, but before I get to them, I'd just like to underscore the fact that the Michigan legislature in 2021, in its legislative fix, removed the 3 primary ways in which Michigan law had extended beyond SORNA by removing the student safety zones, the in-person reporting for minor changes, and for the public nature of the tiering. And as a consequence of that, the Sixth Circuit just this past summer said that this new SORA removed or modified the provisions that the district court opinion had declared unconstitutional. So insofar as Mr. Lyman's relying on federal authority under Doe's, it doesn't support him. But coming back to this court's analysis in Betts, a fair reading of Betts supports the conclusion that Michigan SORA is not facially punitive. And that's because a majority of this court's analysis there related to the student safety zones, which have been repealed, and to the in-person reporting for minor changes, which has been modified and now can be changed by mail. In that opinion, in fact, one of the things you asked Justice Kavanaugh was, well, doesn't the analysis under SORNA, the fact it didn't sever, support the decision of the Court of Appeals? It cuts exactly the opposite. What this court said is, should we sever and make it like SORNA, which would be a safe harbor? We can't do it because it's not clear that the legislature would have made these other changes too, if that's the only thing it wanted to do. But the changes that this court identified, it was an analysis about the role of the court and legislative authority. There was no doubt cast on the question about whether if this were just like SORNA, would it pass? The implication was yes, but we can't do this. That's the job of the legislature. That's the way the Betts opinion reads. So if you look at the other schemes that have been found to be constitutionally firm, which is the Alaska law from 2003, SORNA, which is a universal analysis, or even the Michigan pre-2006 SORA, which this court referenced in the Betts opinion, and the clear implication was the pre-2006 SORA would have passed constitutional muster, which had periodic in-person reporting, which had an offense-based categorization, which the United States Supreme Court expressly stated would meet constitutional standards. And the second point, though, is this. This court doesn't need to reach the issue about whether Michigan's SORA is facially punitive. The claim here, and the Court of Appeals did a facial analysis. What was driving the Court of Appeals analysis was a concern that a person who was not a sex offender was being placed on a list of sex offenders. It's an obvious point, right? I see the strength of the claim, right? We're not trying to say that there's no merit to that point. The question is how you reach that conclusion. When the Michigan Court of Appeals some years ago found the Romeo and Juliet problem and said these people are coming off, the Romeo and Juliet offenders, it was an as-applied analysis. They said it was punitive as applied, and then in particular to him as applied. It wasn't a facial analysis. The case that's coming down the pike that's being held in abeyance, pending this case, is Christopher Johnson, also a Wayne County case. It's an ex post facto case. It's a case in which the Michigan Court of Appeals just picked up Lyman and applied the state the state constitutional claim analysis and applied it to the federal constitutional ex post facto. That's where this court should reach the issue about whether this is facially punitive. Frankly, I think he loses even as an as-applied analysis because, frankly, mislabeling someone is not a claim that sounds under cruel or unusual punishment. If there were a mistake in a pre-sentence investigation report which listed someone as a sex offender, I wouldn't say cruel or unusual punishment. I would raise a due process claim. And that's exactly how the ACLU has brought the claim for the pending case in federal court as a due process or equal protection claim. That is really where the claim, how it should be raised. But what that means, though, for this court is for it to say that it is punitive as a facial matter, it wouldn't govern the ex post facto. We'd still have to wait for that case to come down the line. But if it then reiterated that same analysis in an ex post facto setting, it would place it on a collision course with the federal courts because our law is virtually identical substantively to SORNA now. And if you want to know what the differences were, they were placed in the footnote 27 in Betts. But it's impossible to remember them because they're so technical and small, not consequential. In fact, the SMART office is impressing us because, in fact, we're not as comprehensive as SORNA. SORNA is much tougher on international travel than Michigan law. So there are ways in which we are weaker than SORNA, which has been found not to be punitive. But
Any questions for
Oh, I'm
Mr.
sorry.
Mastruccia? I just don't want you to eat into all of the rebuttal time.
No, that's right. He has 2:45, so I think I have 44 seconds if there are any questions. But I would counsel this. I see Mr. Lyman's claim, right? The strength of it, right? That he shouldn't be labeled a sex offender when he's not. There's no reason for this court to go beyond the as-applied analysis. If the court is interested in granting him relief, it should do so on an as-applied basis. Grant and Johnson, and let's have the discussion about whether the very questions you're asking about under Betts, about whether it is facially punitive, and that discussion can be had. In fact, the case is pending in federal court on the same issue on the ex post facto, and there's a whole record being generated. I'm down to 5 seconds. So if there ain't no further questions for me, I'll save Mr. Voitala's the remainder of his time. That's right. So if there's no questions, I have nothing further.
Thank you very much.
Good morning, Your Honors. Jessica Zimbelman from the State Appellate Defender Office on behalf of Mr. Lyman, who is here with us in court today. Joining me at council table is McKenna Thayer, also from SATO. The prosecutor and the Michigan State Police want this court to look at any statute but the statute that's at issue in front of it. They say it's like pre-2006 Michigan SORA. It's like the statute at issue over 20 years ago in Smith versus Doe's. It's like SORNA. But when you look at this court's opinion in Betts and look at the similarities between 2011 SORA and the current SORA, it becomes obvious that Betts is controlling. This is especially true because the state has branded Mr. Lyman as a sex offender when he is not. Nobody is alleging that Mr. Lyman has committed a sex offense, yet he is being branded, tracked, and shamed by the public and the government as a sex offender. This court in Betts found 2011 SORA to be excessive punishment for 5 primary reasons. Only one of those was the geographic exclusion zones. This court found that over 40,000 people were subject to requirements of SORA without an individualized assessment of risk. The duration was based on an offense, not somebody's actual risk to the community. There was the stigma of being branded a violent menace by the state and in-person reporting, which, as I've outlined in my brief, there is significant in-person reporting. And it also belies reason to say that the option to report by mail is only for minor changes. That shows a lack of understanding of people who come from different socioeconomic backgrounds about when those minor changes may actually frequently change. And that only the major changes, that they might not change that much. But somebody might move houses several times. As outlined in the ACLU's amicus brief, 12% of registrants were homeless at some point. 45% of registrants were unemployed, and that's at a time when the state's unemployment rate was 4.5%. So all of those reasons that this court found 2011 SORA excessive in Betts remain, except for the geographic exclusion zones, which, as Your Honor noted, could have been severed. And this court also, looking at the difference between SORNA in Betts, said there are several deviations. The Michigan State Police pointed out their footnote in the ACLU's amicus brief, note 34, lists further changes. But one I want to highlight for this court, SORNA does not have its own website. When you go to the online registry for SORNA, it directs you to state websites. So you get Michigan's registry. And that, the fundamental change of the internet since the court's decision in Smith versus Doe's makes this like shaming, as this court has already acknowledged in Betts. And this, Your Honor, Justice Welch asked the prosecutor whether this was similar to probation. This court found in Betts that 2011 SORA was like parole. And there are a lot of similarities between parole and probation. And there's even, the differences are actually even more substantive and more stringent for people who are on the registry. And the prosecutor asserted that the website and registry is to protect people for potential dangers out there. But we don't actually know who on the registry presents a risk. And I want to remind this court that the purpose of the legislature in enacting the sex offender registry was to protect people from people recommitting a sex offense. So it's not to protect the public from any vast number of unnamed dangers. It is a very specific purpose. And of course, that loses complete power when you're looking at somebody like Mr. Lyman, who has not committed a sex offense. So all the studies about recidivism that are cited in my brief, in the amicus brief, and the prosecutor's brief really are irrelevant to the question of Mr. Lyman specifically and other people who have not committed sex offenses. And I do think there's room here for the court to consider whether the Kennedy factors are the appropriate test when dealing with Michigan's cruel or unusual punishment clause. Because of course the ex post facto clause is designed to prohibit increased punishment for people who have committed a criminal offense. The cruel or unusual punishment clause is really looking at excessive sanctions. And if you look at the United States Supreme Court case of Austin versus United States, that was an excessive fines clause issue. And the court there said that if a sanction in part punishes, then it can be analyzed as to whether it violates the Eighth Amendment in that case. And I would encourage this court to look to that case as it decides whether the Kennedy factors are the appropriate test when analyzing a sanction under the cruel or unusual punishment clause. And there can be no debate that SORA at least in part punishes people who are on it. One of the Kennedy factors is, of course, whether it serves the traditional aims of punishment, which this court in Betts found that it did. It both deterred and served the purpose of retribution. So this court could look to that. I also think that for a narrower remedy here, I think this court should facially strike SORA as punishment, and certainly unconstitutional, cruel or unusual punishment for people who have not been convicted of a sex offense. There is room here, there's a record here to do that, and this court should do that because of how closely 2021 mirrors 2011. The legislature did not fix the problems identified by this court in Betts. So while I think this court should issue that holding, I think there's a narrower way as well. I think this court could strike the 3 non-sexual offenses that require mandatory registration as unconstitutional, cruel, or unusual punishment. And that gets to Parks and Stovall, where, of course, parolable life and mandatory life without parole are not cruel or unusual punishment on their face, but applied to a specific group of people, they were.
What's your response to the ACLU's position that we don't even need to look at the 2021 Act? That we can look at this through due process?
That is raised in a federal claim.
Yep.
That was not raised here. Perhaps it should have been, but this is a claim that focuses solely on whether it's cruel or unusual punishment.
But I think their position is that that's an avenue that this case can be resolved.
I think it probably could. I think that would probably warrant some further briefing because we haven't briefed the due process violation here. But when looking at protections that are already baked into SORA, with, for example, the catch-all provision, there is a provision in SORA that requires discretionary registration if the trial court makes certain findings that an offense had a sexual component to it. They have to put findings of fact on the record in the trial court, and then that person has to register. So perhaps it is a due process violation that people convicted of these 3 offenses, such as Mr. Lyman, don't have those same protections as people who fall under the catch-all provision. That could be part of a due process violation. And I would be happy to brief that more for this court because it was not briefed that way below.
Counsel, I want to just talk about preservation. I recognize the procedural stance of this. There was a motion for reconsideration under the rules that have to do with sentencing guidelines. Understanding the argument, because of course this is, arguably not punishment, so it doesn't fall under the guidelines in the traditional way. How do we get to this?
Well, I hear you, and certainly filed a motion to remand to preserve the sentencing claim, what we think falls squarely under a sentencing claim. The Court of Appeals did analyze this under a plain error standard and found that the Court of Appeals also did not find preservation there, and Mr. Lyman was still successful under a plain error standard. And I think this court can look to the Court of Appeals analysis there to get to a holding where Mr. Lyman does not have to register.
Thank you.
The court doesn't have any other questions?
I don't see any other
Thank
questions.
you.
Thank you.
With the court's indulgence, Mr. Voital has yielded his 2 minutes rebuttal to me, in part because there was kind of a technical point made that I'm kind of prepared to answer, which is...
Speak very quickly, too.
That's right, well, I got a minute 58. So the statement was that the Federal Registry doesn't maintain its own website. That's inaccurate, it does. It's not a registry, it's a website. So if you look at the statutory site is 34 USC 209220A and B. What it does, and I think the insight that she has, is that the federal registry imports the state registry, but it is independently maintained. In other words, in my amicus brief, I put in Paul Betts, because he has to register under the new SORA. And he also has to register under SORNA. So if you put in
Counsel,
Mr. Betts.
I just have a very quick question.
Sure.
You know me, I like to keep things simple, and you guys have done a great job. The question I have, it just goes down to the simplicity of this. Your sister counsel basically argued that the defendant in this case is not a sexual predator. It was not a sex-based offense. The concept here is to basically be concerned if a crime of this sexual nature would be penetrated again, which is really the essence of this. So what's the point of the extension?
Justice Bernstein, I think that's the nub of the claim here, that for the cohort of offenders, there's 3 classes of offenses that don't have a sexual element. There are 295 offenders in that cohort. The Michigan State Police has complied with the Court of Appeals judgment. Of the 295, 281 of the offenders have come off the registry. Now, that doesn't mean that this court doesn't have an issue to resolve, but what it does mean, though, is that's the group we're talking about, but that's an as-applied analysis. And that's the fundamental point I want to make to this court, is that the issue about whether...
How do we do an as-applied analysis in this context? Do we not do the punishment analysis?
No,
Do we just overlook it?
No. In fact, the threshold question about whether it's punishment. I think the rights test is the Mendoza factors. I'm out of time, but I'll answer the question. The proper test is the Mendoza test, I think. And that's how the federal courts have done on Eighth
But
Amendment
they don't
claims.
set up as an as-applied test.
Well, I don't agree insofar as this. I mean, I'm not arguing that you should grant relief as an as-applied basis, but it's a 5-factor test. The most important factor, does it meet its rational purpose? 4th factor. The question is, if you look at Michigan law, 321A, I could quote it for you, it says it's to protect the public from sexual offenders. So the question is, does it rationally advance the interests of SORA under the 4th factor of the Mendoza test to place on an offender who has no sexual component whatsoever to his offense on a registry designed to protect people from sexual offenders? So that would be under the 4th part of the Mendoza test as an as-applied challenge. And in fact, this court asked questions, ex post facto, asking about as-applied for juveniles in the Temelkowski case. The concept about there being an as-applied challenge occurred in the DiPiazza case, in the Romeo and Juliet, for a state constitutional analysis. So the concept that there could be an as-applied challenge seems perfectly clear. My point about why he would still lose is that a regulatory system doesn't become punitive just because it's misapplied. It would be essentially a due process claim. It's almost like they entered the wrong conviction in the system, and they put one thing as opposed to another, or they had inaccurate information in the report. So I think, insofar as he has a claim, it's the ACLU's due process, and we're not conceding that, but that would be the way the claim should come forward. But this idea that there couldn't be an as-applied challenge, I think is fundamentally wrong. There can be an as-applied challenge, and after the DiPiazza case came through, no one thought, oh, the registry's falling. Whereas if this court rules that this is facially punitive, everyone's going to think that applies in the ex post facto context. And if it applies in the ex post facto context, of course, that's just like Betts, and more than 30,000 offenders, the ability to maintain on the registry will be only dependent on whether this court reaches the severance question. We will recreate the Betts setting. That's not this case. This case is only about the state constitutional claim. There is no reason to join that issue when that identical issue is being pressed by Mr. Johnson, because the Court of Appeals did that very thing. They picked up Lyman and they applied it to his case. So circling back to give a shorter answer, you can do an as-applied analysis, and if we lose on an as-applied basis, it won't affect the registry generally other than these 295 offenders. 281 have already come off, and it will set up the Johnson case, which will then parallel also the federal litigation in which this issue is pending.
Just for curiosity's sake, what happened to the remaining 14 people?
Well, the ruling of the Court of Appeals says there has to be a finding of a sexual element to the crime. So I assume in those 14 cases, my understanding is the prosecutors, at the time of the plea, it included a factual element that demonstrated it, because I don't think you can do it by jury trial because the jury doesn't make a determination on it. So I think those 14, there must have been a plea based. But these were all sent back to the counties, and there were 14 prosecutors who said, we have a sexual element, so we can meet the Lyman test. The warrant manual has been updated as well, and the warrant manual says the only way the person can go into the registry for child enticement, kidnapping, or false imprisonment is where there's a factual basis that's determined beyond, on the record, that shows that there was a sexual element. Because that was the basis for these inclusion into the SORA, is that if you abduct a child, the fear is it's going to be for a sexual reason. Now here, Mr. Lyman terrorized his family, but there was no sexual element to it whatsoever. So an as-applied basis, the DiPiazza case, if this court ruled on that ground, it sets up the Johnson case for the next question, where all the questions that Justice Kavanaugh asked would be relevant, and I think then
So the relief you're not asking us to give, it would require us to affirm on other grounds?
Well, it's essentially the court ruled cruel or unusual punishment. It had an as-applied analysis for the second element. Once it found to be punishment, then it was cruel or unusual with respect to him. The way it would change the analysis, if it ruled against us and against the position we've staked out, is there would be an analysis of the Mendoza factors. It would look at that fourth factor and say, this doesn't make any sense. Why are you putting a sex offender on when he's calling him a sex offender when he's not? How does this protect people from sex offenders when he's not a sex offender? So you'd have this as-applied punitive analysis and say, for him and others similarly situated, it doesn't meet its ends, and it's also the disproportionate, so he gets relief, and all those for whom there is no sexual element to his crime, they also get relief. So those 200...
But I guess I'm just to clear it up, are you saying that the Court of Appeals, that's what they did in this case?
No, the Court of Appeals did not. That's why we're very animated, because what the Court of Appeals
So you
said...
want us to affirm you don't want us to do this, but you're saying if you lose, you'd prefer to lose by us affirming on other grounds.
If we lose narrowly, it leaves this issue for another day. And I think then it gives the court the opportunity to think.
Well, I get the
But also
theory,
the critical
theory.
point.
I'm just trying to apply it.
But
to
also
case.
this, I think this, and this is the piece, this is the insight I think I want to give from the court. This is a state constitutional analysis, right? And under a state constitutional analysis, you rely on the state constitution. You have a federal standard. The ex post facto standard, this court has not reviewed its ex post facto more expansively. If this court says that Michigan SORA is punitive, it will then be in direct conflict with all of the other federal case law that has said that the federal SORNA is not punitive. And that's the decisions this court has to make. But that's the proper basis in which to reach this issue about the facial punitive character, is in a case in which there's an ex post facto claim brought, as opposed to one which is essentially an as-applied challenge for those without a sexual component to the crime.
I think that's a long way of saying yes. Thank you, Mr.
Short for him.
Thank you. All the case will be submitted.